All right, we are live. All right, so my name is Chris Berry with Castle Wealth Group. We do these weekly webinars every week, unless we have to. Whoa, what am I doing? All right, there we go. All right. So yeah, we do these workshops each week, and what we like to do is just answer whatever questions our clients have. So if you do have questions, please put it into the Q&A, and then we'll go ahead and answer those questions as we get started. All right, and let me hit a couple buttons to get this working. There we go. All right, perfect. And we always start with a positive focus. So something positive that happened since the last presentation, and big positive focus is we've moved into our new office in Brighton. So we're super excited about that. And with that, let's go ahead and get started here. All right. So first question. Is a person financially liable when they act as a power of attorney? So I kind of streamlined the question a little bit from how it was asked, but what we're getting at here is this concept of serving as an agent whenever you're serving as either a financial power of attorney, maybe you're serving as a medical power of attorney, maybe you're a trustee. So you're acting as a trustee managing money, maybe you're an executor of a will. The big thing with all of these things is that you're serving really as what's called a fiduciary. And this word fiduciary, it's used different ways as a certified financial planner and an attorney. Like I have to serve as a fiduciary for my clients. But when you're serving as an agent under a financial power of attorney, or serving as an agent under the medical power of attorney, or serving as a trustee here under a trust, or the executor under a will, you're stepping into this role of a fiduciary, meaning you don't actually own the checking account that you're writing a check on. You don't own the investment account that's in the name of the trust. You don't own what's in the trust owns it. Or if you're serving as financial power of attorney for someone, that person owns that account. And so the question was really kind of focusing on this idea of like, all right, I'm serving as a medical power of attorney for someone. Now, let's say they rack up a bunch of long-term care costs or hospital bills or medical bills. Are you liable as the agent for the individual's medical bills? And the answer is no. You're not liable for their expenses. Like you're supposed to use their money for whatever their costs would be. So you would use, and this is where there's some coordination between the medical and financial power of attorney. So the medical power of attorney allows you to make decisions with regards to the medical care, but obviously there's going to be questions of how do you go about paying for that? Well, that's you as a financial power of attorney. You could use that individual's money to write a check and just sign it not in your name. You'd sign it as POA for Jim Smith. So let's say that you were the agent for Jim Smith here. What you would do is you would sign the check. You would sign the check with your name, and then you would just write POA after it. And so you're using Jim Smith's money, his checking account, to pay for his medical bills. Now, if all of those costs kind of ate into Jim Smith's like bank account, it doesn't come after, they can't come after your bank account. The only way that you would ever be liable is if you don't follow this fiduciary standard, if you don't act in the individual's best interest. But typically the person that you're appointing as a financial power of attorney or medical power of attorney or trustee, like you trust them. That's why you're appointing that person. A lot of times it's a spouse and then kids. But really, to specifically answer the question, you're not financially liable when you're acting as a POA for someone, unless you were like embezzling their money or something like that. So you wouldn't be on the hook for their medical bills. So, all right. So yeah, done and done. And let me see, do we have any questions? All right, we'll get to that. All right. So this next question that was submitted already, in a trust with a married couple, when does the tangible personal property get distributed? So let's say we have a married couple. Let's say we have husband and wife. So we have both of them, and they set up a trust. Let's say they set up a castle trust, right? And they put the assets into the trust. And then the question is, upon distribution, when do the assets get distributed? And it's really going to be based on what the trust or the estate plan says. Because again, a trust is like creating, or estate plan is like creating your own rule book. So we could have it upon the first death. So let's say husband passes away. Upon the first death, typically we have everything just go to the survivor. But if there were certain things like maybe he wanted a hunting rifle upon his death to go to his firstborn son or a friend or a brother, you can have it done. So upon the first death, or typically what we see is upon the second death. That's when all the personal property would be distributed. But we'd have to follow the terms of the trust. So a lot of times if it's like second marriages with kids from previous marriages, maybe upon the first death, we have some assets going back to the family versus all going to the surviving spouse. Versus if it's a first marriage with kids from a common marriage, then typically it would be upon the second death. But to answer their question, when does the tangible personal property get distributed? It's whatever the estate plan says. So whatever the trust says. And by creating that estate plan and creating that rule book, we can decide if personal property, like jewelry and things like that, go upon the first death, or is it everything to the surviving spouse, and then upon the second death, that's when the personal property would get distributed. Okay, so it's really up to the estate plan. Another question here, can I put required minimum distributions? So RMDs are what's called required minimum distributions. And these happen in really pre-tax accounts like traditional 401ks. The big one is IRAs. And so what happens at age 72, now with Secure Act 2.0, that's pushed back to 73 to potentially 75, depending on your age. What's going to happen on these pre-tax accounts is that you have to take money out and pay tax. Okay, so that's called a required minimum distribution. Now, what a lot of people do, and also the question was, can I put RMD into a trust? The answer to that is yes. And then also a question was, so you pay the tax on the IRA and you can put it in a trust. And then also the question was, can I do a Roth conversion or Roth? So both of these, whether we're talking about a trust, or we're talking about putting the money into the Roth, we call both of these an IRA exit strategy. So you're taking money out of the IRA, paying the tax, and looking at what you can do with it. So with this forced required minimum distribution, you can put it into the trust, but you cannot put it into a Roth. You cannot put a RMD, required minimum distribution, from an IRA, can go into a trust. It cannot go into a Roth. Okay, what you would have to do is you would have to do what's called Roth conversions. And with the Roth conversion, what you would do is take money from the IRA and you would move the money directly into the Roth. The only downside is you have to pay the tax. Okay, but before you can do a Roth conversion, you have to first take out your required minimum distributions. Okay. So if you have, say, a $20,000 required minimum distribution, you have to take that money out of the IRA, pay the tax, and it can go into a trust. It can go into your checking account. You can spend the money, but it cannot go into a Roth. And then once you've done that RMD, then you could look at Roth conversions based on your tax brackets. So the answer to the question, can I put an RMD into a trust? The answer to that is yes. But can I put my RMD into a Roth? The answer to that is no. We'd have to do a Roth conversion. That would have to be a separate transaction. So that's another reason why a lot of times we're looking at paying the money on the IRA sooner rather than later, so we can do things. So we're not forced to take out these required minimum distributions, where now the money has to go into a post-tax account like a trust. It can't go into an RMD. All right. Okay. All right, cool. All right, so a couple more questions just came in. This one was just emailed. My sister owns a condo. All right, so we have sister owns a condo. She needs long-term care. We've hired staff, so we have home care coming in. If we want to hire, does not work for an agency, what should we do? For example, is there something? All right, so here's a situation. So we have a loved one who's receiving home care. Okay, so we have someone coming in, and there's two types of home care that we see. We have a lot of home care companies or agencies that we utilize. The nice thing about an agency is like they'll have like backup if a caregiver is out, but especially since the pandemic, finding caregivers has been really, really hard. Or you can have just kind of like individuals, like, hey, I know this person, and like their neighbor or family member, and they're going to provide care. So the question is, if we wanted to hire an individual that does not work for an agency, what should we be doing to cover any liability for the person? So the question is, okay, we're bringing in an individual into the home to care for our sister. The question is, what type of kind of liability is there, or what can you do to protect liability? Is this something we should be doing? Can you suggest something else that would protect my sister if we're able to find the right person? Yeah, so obviously we want to, the concern is protecting the sister, so we don't want any liability coming back to her. I don't think really there's anything that should be done, like in terms of like a LLC, a limited liability company or something like that. I don't think that would make the most sense. If you're concerned with like someone coming in the house and now there's a slip and fall or something like that. My sister owns a condo and mother lives there by herself. Yeah, so if sister owns the condo, assuming it is like the homestead, then we would not recommend a LLC. If it was like a cottage or second piece of property, or any second piece of property, then that's typically where we would look to the LLC. Because if there's a slip and fall, they could come after any assets. But by putting this cottage into a LLC or the second property into LLC, you're limiting the liability. But you would not do it if it's a personal residence, because that would screw up your tax status. So if you are concerned with liability coming in to this, to the home, and it's a primary residence, what I would recommend is upping your umbrella policy. So your umbrella insurance, this would be through your property and casualty person, and it's super cheap, like $1 million of umbrella coverage, which like covers every other scenario other than like auto and stuff like that, maybe costs $200 to $300 a year. So it's super cheap. So if you're concerned about liability because you have individuals coming into a primary residence, I would look at the umbrella policy to cover that. If they were in a second piece of property, then I'd look at an LLC plus the umbrella. But if it's just someone's primary homestead, then an LLC I wouldn't recommend LLC. Just get the umbrella policy. All right. So that's that. All right, a couple more questions here came in. Can a trust be set up so one of the heirs can receive their share of inheritance only if they first set up a will and trust for themselves? Okay, all right. So the question here is, all right, let's say we have an individual and they want to provide for a child and they want a trust to provide for the child, but they want to build in conditions. And the specific situation is, hey, I want to set up a trust so to take care of an heir, a loved one, but the only way they can get the money is if they meet a certain condition. And so in this situation, the condition was, I want my child to set up a will or a trust for themselves. Yeah, so in your trust, your estate plan, you can build in whatever conditions that you want, because it's creating your rule book. So a lot of times, like, we build in provisions to say it's not going to go outright to someone who's under the age of 25. Instead, it'll be held in trust for their benefit. Like, my kids are 10 and 12 now. If they inherited money, they'd spend it all on like stuffed animals and video games. Like, it's not the best use of the money. So I've built in conditions to say that it's going to be held in trust until they reach a certain age. So that's just a different type of condition. So this question was asking, hey, I want to build in a condition where the money is going to be held in trust unless my beneficiary sets up a will or trust. Well, if that could be built into your estate plan, whether it's a good idea or not, that's another conversation, but that's certainly something that could be built into a estate plan. And taking it one step further, this wasn't the question. There's been some interesting cases, even like court cases, where people build in like things where they have to marry someone of the same religious faith to receive an inheritance. In fact, in a estate plan I did for a woman a number of years ago, she had a bunch of kids. This is her words, they're kind of derelicts. And so the condition she built into the trust was that they have to pay back any back child support. They have to have a driver's license. They have to stay out of jail. They have to do community service at the Humane Society. And then I forget what some of the other requirements were. But if they met all these conditions, then they'd receive like a $250,000 inheritance. If they didn't, then that money would go to a charity, which was the Humane Society. So yeah, so to answer your question, yes, you can build in conditions into your trust or estate plan. We typically don't want it to be too convoluted. I'm a big fan of simplicity, but if there's specific reasons why we want to build in specific conditions, we can certainly do that. All right, answer that question. All right, now the next question, what is the procedure to not renew an annual CD put into an IRA into either income to me, trust, okay, all right. So the question here is, we have an IRA. So think of an IRA just like a trust or anything else. Like it's a container, and we can have different types of investments inside of that container. So we could have the money in stocks, we could have it in bonds. And this question is saying, hey, I have a CD, certificate of deposit, that is inside of an IRA. So what is the procedure not to renew an annual CD put in an IRA into either income to me or into a trust or a Roth conversion? My RMD of my own is next year. I'm 72 and 73. Okay. Yeah, so the question is, how do I not renew the CD? Because these are built on typically a time horizon. And typically what happens is they get cashed out like after a year or so. So what you would do is you would just, whoever is kind of managing the IRA, you would contact them and say, hey, I want to take out RMDs, or I want to cash that out, or something like that. So just question of not renewing a CD, just reach out to the company that's managing the IRA to make sure that they don't that you can do whatever you want with CD once it comes due. Okay. Let's see, any other questions? All right, so that is all I have, everyone. If you have any questions on any of this, feel free to reach out. Just shoot us an email or give us a call. And I appreciate the questions, and we'll be back next week. Thank you so much. Take care.